Can you opt out of a binding arbitration clause? Have you ever wondered if you can opt out of a binding arbitration clause during a divorce or separation? This is an important question that many couples face when navigating legal agreements. Let's break it down simply. A binding arbitration clause is a part of an agreement where both spouses decide to resolve disputes through arbitration instead of going to court. In this process, a neutral third party, known as an arbitrator, listens to both sides and makes a final decision. Now, whether you can opt out of this clause largely depends on the specific terms of the arbitration agreement. First, check if there is an opt-out provision included. Some agreements allow one or both parties to reject arbitration within a certain time frame after signing. If such a provision exists, you can follow the outlined procedure to opt out. This means you can take your disputes to court instead of being bound to arbitration. If there is no opt-out provision in the agreement, you generally cannot refuse arbitration once you have agreed to it. Courts usually enforce these binding arbitration clauses unless there is a legal issue, such as not being clearly informed about waiving your right to sue in court. Without an opt-out option, you will need to resolve disputes through arbitration. Timing is also crucial. The opportunity to opt out usually exists only before arbitration proceedings begin or within a short period after signing the agreement. Once that window closes, opting out is typically no longer an option. In some cases, courts may reject arbitration clauses that do not provide a clear opt-out option or that seem unfair to one party. For example, if a party was not adequately informed about the implications of the arbitration clause, a court may find it unenforceable. This could allow a party to avoid arbitration despite the clause. In divorce cases, arbitration can help resolve contested issues like property division, child custody, or support. If spouses have agreed to binding arbitration, opting out may not be straightforward unless the agreement allows it. Remember, arbitration decisions are binding and usually become part of the final divorce decree approved by the court. Alternatively, some couples may choose non-binding arbitration, where the arbitrator's decision is advisory rather than final. In this case, either party can reject the decision and proceed to court. However, this differs from binding arbitration, where the decision is final unless challenged on limited legal grounds. To sum it up, you can opt out of a binding arbitration clause only if the clause explicitly provides an opt-out option and you act within the specified time frame. Without such a provision, you are generally bound to arbitration. In divorce and separation matters, this means accepting the arbitrator's decision on disputed issues, which will then be submitted to the court for approval. If you are unsure about your rights or the enforceability of an arbitration clause, consulting a family law attorney is a smart move.